possible in part by the Dayton Bar Association.
Well, there I am. Hello, welcome to You and the Law. Am I on?
They didn't say anything.
Nobody say anything. Well, I'm going to assume I'm on for all you viewers out there. I'm Mike Monta, the producer and host for today's program, and we're talking about laws of drunk driving. In fact, December, I believe, is National Impaired Driving Month. Under the MADD organization. So it's appropriate. We're coming into the holiday season, and sometimes there's more of a tendency to imbibe. Not that you can't, but everybody should be careful. We have experts on our show, and Larry Denny is here, I think for about his 8th consecutive DUI drunk driving program. Renowned defense attorney here in the tri-state area. I don't know if you're in the I know you're all over the place, and has been doing defensive DUI cases for a long time. And Mr. Chris Eppley is assistant prosecutor for the city of Vandalia and has been doing that for a long time, and will be able to tell us something about the prosecution of these cases. Judge Thomas Hanna from Kettering Municipal Court, I understand he is, we hope, on his way. He had a case late this afternoon and may be detained, but we hope to have him also. Before we get to our panel discussion, let me remind you that You and the Law is a monthly presentation produced here at the studios of Dayton Access Television. DATV is on Channel 5. It's the public access channel of Time Warner here in Dayton, Ohio. And it's also cable cast via the auspices of the Miami Cable Council, north and south. The show is also streams live at datv.org. Executive producer for the program is the originator of the show, a former domestic relations judge, Mike Brigner. This is an audience participation program. If you well, there should be a number, and I think it's 223-5311. They'll put a graphic up here any time now. And when you do see that, if you have a question, call in. Now, I understand technically our phones aren't working, but there it is, 223-5311. And please call in. Your questions will be relayed. Maybe they'll get them working so we can actually talk to you. But we can answer your questions. So if you do call in, tell us who you are, where you're calling from, what the question is, and we'll be able to answer that. So at this point, well, let me tell you something else. We are sponsored by the Dayton Bar Association, and I think they would be happy to have me tell you about that just a little bit. Dayton Bar Association's been serving our community since 1883, longer than Larry and I have been practicing anyway, maybe combined, I don't know. Bill Wheeler is the executive director and doing a great job. We're happy that they're sponsoring us and hope we're doing the Bar Association proud also. So we'll tell you a little bit more about that later. Also, during the program, we hope to have a demonstration of field sobriety tests, so that ought to be kind of fun too. So let us turn to our guests now and have them introduce themselves more fully, tell you a little bit about themselves, their familiarity with tonight's topic and their experience. And we'll turn first to Mr. Chris Eppley. Good evening, Chris. Nice to have you on the show.
Good evening, Mike. Thanks for having me. I've been prosecuting in the city of Vandalia Municipal Court since January 2000.
Vandalia Municipal Court includes the city of Vandalia, Inglewood, Clayton, Union, Harrison Township, and Butler Township. And I prosecute on behalf of all those jurisdictions except for Inglewood. It also includes the Ohio State Patrol. In addition to prosecuting part-time in Vandalia, I have a practice downtown Dayton that includes some DUI work and some other domestic relations work. And in addition, I am on the school board at Oakwood City School District.
Great. That's fantastic. Nice to have you. And an old friend of ours from many shows, Mr. Larry Denny, who he can tell you about his polo horses at some point. But nice to have you, and tell us a little bit about.
I went to Senator College in Danville, Kentucky, where they had the vice presidential debates, even though it was before them. And Northern Kentucky State for my law degree, and I have a law office downtown Dayton, and I go to about 35 different courts from Cincinnati to Batavia to Eaton and up to Lima, but predominantly the Dayton close-knit area, doing DUI defense. And I've been to the National DUI College at Harvard, and I've completed the field sobriety teacher and instructor certificate, and I've been certified at the factory that makes the breath machine up in Mansfield. So I do DUI defense.
And there's a new machine, a breath analyzer machine, which we'll talk about in a little bit, and you can give us some of the history of that maybe as we go along. So, well, our topic is drunk driving, but I think the law encompasses more than that, and it doesn't specify necessarily that you have to be drunk. You can be drunk, I suppose, and be in compliance with the law. So let me ask Chris, what is the process here? What are the law enforcement officers looking for out on the street from the driving impairment?
Well, sure, Mike. What they're looking for is impairment, and by that definition, they mean appreciably impaired to operate a motor vehicle. And so the first thing they're looking for is the driving itself, whether there's weaving, which is one of the most common indicia of impairment, is weaving within lanes or crossing over into a center lane. And if they do that for a while, then that's going to draw a police officer's attention. In addition, they may be other traffic infractions, not having a turn indicator, running a red light, something like that, that at least draws the officer's attention to the vehicle and gives them a reason to stop the vehicle.
Well, let me stop you just for a second. And a lot of times we hear, and I don't know if they're old wives' tales or what kind of tales they are, but the police are waiting at the bar at 1:30 in the morning and just randomly cherry picking and doing that. But you've already indicated that some traffic violation or something like that needs to occur.
There has to be some traffic violation, that's correct, and it can't necessarily be just de minimis. There has to be something that...
De minimis meaning what for our...
De minimis meaning a very small infraction. Okay. So you, for example, you didn't stop right before the sidewalk that leads to the roadway like you're supposed to do. Probably most of us don't. There has to be something more than that when people are leaving a bar, for example. That type of small infraction may not get the officer's attention. But if you go flying out of a parking lot, don't have an indicator on, and cross over into a center lane before you get back into the correct lane, that's going to draw an officer's attention.
One of the things which is, well, it's not brand new, but it is newer, is the officers have cameras in their car. Are those helpful in making arrests?
They are absolutely helpful. They're also helpful in the prosecution of the cases because we can review those with defense counsel, and we can point out what are the good parts, for example, of a prosecutor's case, and then what are the weak parts. And then we can take that video and decide whether there's some kind of offer that can be made to resolve the matter, and if need be, ultimately show the judge as to why we're coming to the conclusion to make an offer or not to make an offer. And further, if we end up going to trial or having a motion, we can play that video and let the judge decide whether the infractions that I see or the defense attorney sees are actually violations of law.
Okay. I'm going to get to Larry in just a second, but what I want to ask you is when you're prosecuting the cases, and of course the files come in your desk, you're not out making any arrests or anything like that. What do you expect to see in a case file of the typical arrestee for DUI, OVI, etc.? What are you looking for?
I would call them sort of magic word indicators. So these indicators are perhaps bloodshot eyes, slurred speech, an odor of alcohol about the person. And usually we'd like to see something like a strong odor of alcohol. Simply a mere odor of alcohol doesn't necessarily relate to impaired driving. However, we certainly want the officer's honesty, so whatever's in the report is what we're going for. If it's a one-paragraph report, that may not be enough for us to review the case thoroughly, and out of fairness to the defendant or the defense counsel, we may have to bring the officer in to further describe the report that he's written.
We're also looking for certain types of what they call sobriety tests, either chemical or scientific or just out on the road.
Absolutely. Once those indicators have been found, and then the officer has a reason to talk to the person, bring him out of the car, and then do standardized field sobriety tests. And those may be what's commonly known as the pen test, which is the horizontal gaze nystagmus, which, as I understand, it's the to and fro oscillation of the eyes.
Well, there you go. Larry knows about that, and he's going to tell us in a few minutes.
Yes, and then we'll also have the walk and turn test, and then the one-leg stand test. And those are the standardized field sobriety tests that we're looking for. There's typically a checklist in the file that the officer will go over so we can see what factors were present when he did those tests with the driver.
Okay. Well, let's turn to Larry. You're sitting in your office, it's Monday morning, something like that, maybe reading the racing form or whatever, and somebody calls up and says they've been arrested for, they probably say drunk driving, and you make an appointment for them to come in, or somebody makes an appointment. You see them. What are you looking to discuss with a potential client who's been charged?
Well, I do take a pretty extensive history of the person, because if somebody has diabetes, they may have a neuropathy of their feet and not have good balance. If they're over 50 pounds overweight, they shouldn't be given one of these field sobriety tests because they don't have the right balance according to the manual. If they have other ailments, they may give off the odor of alcohol that would explain why the officer smelled this odor that was maybe not alcohol. So I want to take a full medical history. I also want to go through what happened that night. Where were you? What did you have to drink? How much of it? What was the concentration of those beverages? And then their version of what happened, where you were going, where you were coming from, how did the officer treat you, what did you feel like? So I'll take a history of it. And then, of course, their prior driving record will be very important.
It's important to know which jurisdiction, I suppose.
It is. Many different jurisdictions have different judges, prosecutors, and police officers, and each one has their own preferences or way of doing things.
One of the things you talked about was odor of alcohol, and I think probably every new lawyer who goes into this sort of practice, the first thing they tell them is, well, alcohol doesn't have any odor at all. But so what are we really talking about there?
The beverages that we drink are made up of alcohol, but they're made with different hops and lagers and different grains. And the different grains have different odors that when the brewing process. So a beer would give off a different odor than would a rye whiskey or a bourbon. So the odor they smell comes from the other parts of the beverage that's being drunk, not the pure alcohol form itself.
Okay. It's an indicator,
right,
that the person has probably been drinking alcohol.
It is an indicator of drinking. It's also misunderstood sometimes because you may have a strong odor of drinking, but the strength of the odor comes more about how recent you were drinking Versus if I just had a drink right now and only drank one, I'm going to smell pretty strong. If I drank 5 of them 2 hours ago, I may not have but a very mild odor, whereas I may be more likely impaired with a weaker odor that was from a larger quantity.
Okay. Chris, normally I'd ask the judge this question, but when the person who is charged has taken, say, a breath test, what limits are we looking at that the law will consider them impaired?
Well, if the driver is under 21, the limit for alcohol is on their breath is 0.02. And for someone...
No, they shouldn't be drinking at all, but in case they were at home with permission or something,
that's correct.
Would be okay.
And that's why it's such a low limit, because they shouldn't be drinking at all. But for someone who is over 21, then it's above 0.08, and that's known as a first tier test. And then there's a higher tier test, which is 0.17. What the higher tier test does is basically double the amount of jail time that's a mandatory minimum you would be facing.
What sort of, okay, somebody's charged. First of all, Larry, tell us whether it's a good idea to represent yourself in these cases when you're charged.
You know, everybody would expect me to say, no, it's not. And there are good reasons why in this area of the law you shouldn't. And that is because in the Ohio Revised Code, in the criminal section, the largest part of the entire code is for just the DUI violation itself. All the rest of homicide, kidnapping, rape, murder, theft, all those added up don't add up to as many pages as the DUI section. And that section changes every 6 months to a year. So you need to be brought up to date with what's in the law to really be very effective. There are sanctions that vary depending on the number of offenses and what happens. So, you know, you may have to forfeit your car and not know it. You may have to have an automatic device put on your car and not know it. Or the party plate. There's a lot of things that go into this that just, you know, reading a little bit of the law and representing yourself wouldn't permit.
Thank you. We have a question from our viewing audience, and thank you for watching and calling in. And the question is, what vehicles covered under statute does it mean to operate? And that's a good point, because when you said the motor vehicle, I think the law includes you being the motor, right?
I suppose it does, but you could be on a bicycle, you could be on a lawnmower, and still find yourself... Tractor.
All right. And is that all inclusive of the OVI or OMVI statute then?
It used to be that if you were on a bicycle, it was not included. Then that changed. And even though you don't have to have a driver's license to ride a bicycle, you can have your driver's license suspended if you have a DUI on a bicycle. And so there are many steps that would be included in that.
Well, you don't need a license to drive a lawn tractor or or to ride a bicycle or maybe what are the things that you stand on and they move? Scooters.
Skateboard.
Oh, the what is that single thing? I know what you're talking about.
Yeah, I don't. Yeah. So you don't need a license for any of those, but you can be operating impaired under the law, and all the laws apply to you then.
Right. That's correct.
You drive down to the neighborhood bar on your bicycle. You should walk your bike home, or then?
You would have to if you're impaired. If you just had a few beverages and weren't under the influence as defined by law, you could ride it home.
Okay. I hope that answers the question of our viewer, and thank you for calling in. We're sorry we couldn't actually talk to you.
There's even a fellow in Kentucky that's had 2 DUIs driving a horse. So
another mode of transportation.
Right.
Any mode of transportation, you'd be susceptible to it?
That's right.
Okay. If anybody out there knows an exception, call in, but beware. just because you're not driving doesn't mean this doesn't cover you. Okay, penalties. What sort of thing are we looking at all the way from first offense all the way up to multiple offenders?
Well, as Larry was stating, it does depend on if you've had any prior offenses, and the courts look to those to determine how to sentence you. So
Let's talk first offender.
A first-time offender, again, it depends on whether you've refused the test, whether you've tested in the low tier or the high tier. If you tested in the low tier, which is 0.08, between 0.08 and 0.17, then you're looking at a mandatory minimum 3 days in jail. Many times that's substituted with a weekend intervention program.
But it's got to be 72 consecutive hours somewhere.
That's correct.
Okay.
That's correct. Then you're also looking at a minimum fine of $375, potential and most likely court cost as well. A 6-month driver's license suspension is a good possibility. That's a mandatory minimum amount of time. So those are things you are looking at that the court and the BMV will do to you.
And no privileges to drive at all
away.
away.
I was going to ask you about that. I'll bet you that when people come into your office, say, I work, I got to take my kids to school, something like that. When can I get my license back? I've been suspended. They took my license.
Right.
What do you tell them?
Well, if they refuse the breath test, the first 30 days of your first refusal, you won't be able to get any privileges at all, unless there's something defective in the document or the procedure and you appeal it. And you have to appeal that administrative suspension within 30 days. But if you took the breath test, you won't be able to get privileges for the first 15 days of your first offense. Now, if you have multiple offenses, it could go, you can't get it for 90 days or longer, any privileges. And the more you've been refused and suspended, the more the length of time for your suspension.
Okay. We have about 35 minutes. In about 3 or 4 minutes, I'm going to ask Larry to administer some of the field sobriety tests, which he's qualified to do. So I know we have a volunteer here somewhere, and I'm sure he's completely sober. And I think I have another question here too, so maybe I don't. Well, Larry, you want to do that right now? I see our volunteer is showing up, and it's Eric, right? Okay. Well, you'll be. Well, now we have to put. Okay. While Larry's going out to the street here and putting the batteries back in, Chris, tell us about. And Larry alluded to the administrative license suspensions. Tell us, they can suspend you right when they're arresting you.
That's correct, because when you're driving, when you're operating a motor vehicle, you've given implied consent to be able to take your license. So the BMV, if you refuse a test or if you test above the legal limit, then you would be automatically given an administrative license suspension. And in our lawyer lingo, we call that the ALS.
It's like a whole year.
It is a whole year. That's correct on a refusal. And many times, however, the court, if you plead to the OVI, for example, then they can terminate the ALS and institute its own court suspension.
So with the ALS, though, unless you appeal that, even if you say we're found not guilty of the original charge, you'd still be under suspension.
That's correct. You
Okay.
could go to trial unless you appealed it.
I'm looking out here. Have we got a camera on our subjects? Got a camera on me, but do we have one out at the? We do. Okay, we're out in our simulated roadside stop, and Larry, take it away.
All right, I'm going to ask you to do some exercise here. I want you to stand, and I want you to put your right foot in front of your left and touch your heel to your toe, and stand that way with your hands at your side until I tell you what to do, and don't move or don't do anything until I tell you. Will you understand?
Yes.
All right, I'm going to ask you to take heel to toe steps, touching your heel to your toe as you walk down a straight line. And I'm going to ask you to start in the first step. I'm going to have you count number 1 and count 9 steps out. when you get out there, I'm going to have you take little pivot steps, 3 steps around, and then take 9 heel-to-toe steps coming back.
Okay.
And I want you to count out loud, keep your hands at your side, don't stop along the way, and turn as I've instructed. Do you understand?
Yes.
All right. Are you ready to start?
Larry, let me break in just for a second. Don't get the camera on me or anything, but, and what is this test called?
This is called a walk-and-turn test, and there are certain keys along the way I'm going to see if he did them right. If he has 2 clues wrong on all of the clues that I can look for, then he would have failed this test. We're going to see what he does, and I'll clue it and tell you what he did wrong at the end.
Okay, and the relation of this to the impaired driving is what then?
Then if he has, of the 3 tests that we would give him, this being one, if he fails 2 of the 3, then I have developed enough information that he is impaired, then I have an arrest decision point to go arrest him for DUI.
Okay.
If he hadn't violated these tests, then I should not arrest him. I should cite him for whatever marked lanes or whatever it is and let him go on his way.
Okay. Go ahead as you were then.
All right, put your left foot in front of your right and start with your right foot. Do you understand?
Yes.
Hands at your side. Ready? Begin.
1, 2, 3, 4, 5, 6, 7, 8, 9. Pivot. Okay. 1, 2, 3, 4, 5, 6, 7, 8, 9.
All right, very good. Now, what I saw here was he did not stop along the way, kept his hands at his side, except for on number 3 going out, he raised his left hand more than 6 inches from his side. That's one clue. When he got out here, he made the turn, he continued to walk, he kept his hands at his side. Now, he only had 1 clue out of all the possible clues. Therefore, he did not fail that test. There would be other tests I would give him, and it would be a finger-to-nose test.
Why don't we do that? You've got him right there.
I got him right here. We'll do it.
Actually, Eric, you as the volunteer here, and of course you're working on the set tonight, are not impaired, right?
Right.
Okay. But Larry, if he was, you might expect to. This would be hard to do.
Yes.
It's probably hard to do if you've had nothing to drink.
The stress of the nervousness of being on the side of the road, perhaps being arrested, traffic going by, your friends watching you, and you may be very cold. The weather conditions put a lot of factors in play.
Okay.
All right, I'm going to give you a different test. We're going to do what's called the one-leg stand test, all right? I'm going to have you stand on one leg with your hands at your side, keep them at your side, raise your leg out and count 1001, 1002, 1003 to 30, keeping your foot out 6 inches off the ground with your toe pointed forward and looking at your toe. Do you understand those instructions?
Yes.
All right, I want you to begin now.
1001, 1002, 1003, 1004, 1005, 1006, 1007, 1008, 2009, 2010, 2011, 2012, 2013, 2014, 2015, 2016, 2017, 2018, 2019, 2020, 2021, 2022, 2023, 2024, 2025, 2026, 2027, 2028, 2029, 2030.
Very good. Put your foot down. Now, he didn't have any bad clues on that test. He did follow my instructions, and he didn't put his foot down. He didn't sway. One of the things we see is a lot of swaying and hopping, or using his arm for balance, or putting his foot down, or not watching, or not counting correctly. So one of these 4 clues could have been there. He had none of those 4 clues. He almost swayed a little bit, but it is very difficult for the average person to do that test. And when you get to about 26 to 29 or 30, that's when most people put their foot down or sway. So it's reasonable to understand when somebody gets that high, they may do that.
Is this harder, say, as people get older, or for gender differences or anything like that?
Of course. Not only that, a very big thing is the type of shoe you have on. Women who have on perhaps a high heel, or men who have on a cowboy boot with a high heel on it, would have different shifting of their weight and balance. The weather conditions, your weight. Even the manual says if you're 50 pounds overweight, you shouldn't be given that test because your body's out of alignment and weight. So there are many issues that would affect it. And over 65 years of age shouldn't be given that test.
Okay, Chris, any questions that you have at this point for Larry?
No, Larry did the tests correctly. Obviously, he knows how to do these tests, and I was observing the subject the whole time because I've seen many videos of people swaying, and there's a lot of that, even falling over, and there are no clues on that one.
Yeah, these are generally done if there is a camera with a police car showing all of this happening, isn't it?
Pretty much of it. It's coming from the front of the police officer down on this from the back of the police officer, who may be in the way some, or they may not be able to see the feet, but you can see the person pretty much. Sometimes the officers claim they'll take this man off the side of the road to do some of these for the officer's safety of not standing between the cars. Well, I think the officer's safety is not a good concern there. It really should be videotaped or the camera moved that direction. So, you know, be alert when they take them off the camera for their safety.
Yeah, also, and I did want to ask, these are not actually scientific tests. They are, I think they're more properly called field coordination.
Well, to be honest with you, there were studies done by Marcella Burns and two other scientists, and they reviewed these, and they concluded there's reliability at 65 and various percentages. And they did tests to determine it. They got rid of some tests that weren't scientifically reliable. So they claim these are scientifically reliable if done in compliance with the directions and instructions that are set forth. So many times Chris and I may have a battle on whether the officer gave the instructions correctly, used the right words, or scored him correctly. Sometimes an officer may say, you know, the person moved around a little bit. Well, that isn't one of the clues. Swaying is. So if they don't do them as directed, those tests don't count. But if they do them as indicated, and only those 3 tests are recognized scientifically in Ohio, then those tests would be admissible and are claimed to be scientifically reliable. Although that level of scientific reliability wouldn't be accepted in any other world of science.
So essentially they've done away with the picking up the coins test,
Yes.
which was always a favorite.
Right.
And the counting backwards from 100, I think, was one of them.
Now, they still will ask you to do many unreliable activities. You know, finger count, say your ABCs from E to K, anything. And of course, what people realize, or may not realize, you don't have to do any of those gymnastics or exercises if you don't want to. There are no sanctions against you for refusing those.
Okay.
Now, the law gives a sanction for you refusing to blow into the breath machine if they ask you to blow. So that's a different issue.
Okay, well, we'll talk about that as we go along. Are there any other notable tests that we should talk about while you've got Eric here?
Well, I've got him here. There's one called the horizontal gaze nystagmus test. Some people call it the jiggly eye test. But at any rate, I'm going to have a pen that I'll hold out here, and I'm going to ask you.
Tell us before you do it what you're expecting to see and what the eyes are supposed to be doing of a completely sober as opposed to an impaired.
Alcohol affects the eye, the optic nerve, in a way that it causes your eye to jerk as it travels along a plane. And the farther out you get, the more it's going to jerk harder. Now, jerk is like a marble rolling across a piece of gritty sandpaper. It won't roll smoothly. It'll roll with little jerks. And only I can see that in his eye. He can't tell he's doing it as he looks out. So the test is fundamentally that I will hold a pen between 12 and 15 inches from his face. I'll move it to the left and to the right, and he'll watch as I do that. I have to do it at a certain rate, 4 seconds out, hold it for 2 seconds, 4 seconds back, 4 seconds out, hold it for 2 seconds, come back. So I'll do this test, this exercise, which takes about anywhere from 64 to 108 seconds, depending on how you instruct. But it takes a lot, almost a full minute. And so I do that, and I watch his eyes. I want to see when it begins to jerk early on, or whether it continues to jerk continuously when I get out to 45 degrees, and whether there's any vertical segments. Alcohol affects the horizontal. Drugs of certain kind affect the vertical. I may have drugs and alcohol. So an officer would maybe do a vertical nystagmus and figure that out.
Now, the difference between this test and those physical coordination tests you did before, with some tolerance, maybe the walking the line and holding your foot up, there might be some control, but there is not control.
The person can't control his eyes. Moreover, we can't see this on the tape. Almost never can the video pick any of this up. So it's up to the officer to say what he saw.
Okay.
But we can see what the officer does in terms of the correctness of his movement.
All right.
And the person doing it doesn't know. They always say, I passed that test, thinking they followed it, but they don't know what the officer saw in their eyes.
Right. Okay, go ahead and
Thank you.
thank you, Eric.
Yep.
And we'll come back to the studio here. While we were talking, we did have another question, so I will read that and thank the caller. Again, our phones aren't working, but that's okay. This question is, are there any other ways to operate a vehicle without driving that are covered under statute? For example, sitting in the car, operating the radio, and I guess the back seat or something like that. And 20 years ago, I think if you were just in the car and the keys were somewhere, either you had them or they're in the ignition, whether you're in the back, front, or in the trunk, you were operating. But it's changed since then.
They've changed the law about it. It used to be in physical control of the vehicle included operation. Physical control means you're sitting there, you're not running the car, the key's not on, or the key's on, you're just listening to the radio, but you're not driving, you're not operating it. And now they have a law called physical control. You're not allowed to be in physical control of the vehicle and be impaired, but it's different as terms of its sanctions and penalties than a DUI. They'd rather you stop and park and be guilty of just physical control than they would be drive down the road and operate.
So you can be loaded and
Parking.
in the back seat of the car, or waiting to sober up or something like that.
Right, and I think that's the legislators recognized some of the
What
draconian
took them so long?
penalties, right? The harsh penalties of the person who wants to sleep off something. They may have been impaired, knew they were impaired, and in some situations you'll see that they turn the heat on in the middle of winter. So the car's running perhaps, but they're in the physical control of it, but they're not operating it. They're in the parking lot of a bar.
Okay. For our uneducated viewers, not that they're uneducated, but in this subject, what's the threshold then from that into operation, or does it just vary from case to case? Is it a matter of interpretation?
Regarding the physical control?
Yeah, whether you're operating the vehicle such that you could get a DUI on it.
Well, if no one has seen you driving it,
Okay.
then it's going to be difficult from the prosecution standpoint to prove the OVI. If someone finds you at a bar, for example, parking lot, you may have just walked out of the bar, stayed in your car, and that's it. You never operated it. That's the physical control. We can't make the assumption that you drove to the bar while you were impaired, and therefore we have the OVI offense. So that's the difference. If you're just in a parking lot of a bar, and that's the physical control.
We've briefly talked about being under the influence of drugs, which is a newer thing, at least in the past, probably more of it in the past 10 years than there were back in the 70s, 80s, and 90s. are there any things to be looking for there? Any chemical tests? Any thresholds?
There are
You're
chemical
going to the
tests.
chart, yes.
Yes, and my reading glasses as well. There are different drugs that have tests or limits associated with them. And so the controlled substance may be amphetamine, cocaine metabolite, heroin, LSD, marijuana metabolite, and so forth. And they have different nanograms that once you surpass those, you can be the per se level of an OVI.
What?
But Mike, you can have a normal prescription blood pressure medicine and 2 or 3 beers, and if they had enough blood pressure medicine plus you had your beer, even though your beer was maybe not over 0.08, the combination of drugs and alcohol, if that drug is a prescription drug that says don't be drinking it with it, that combination could be a prohibited, and it is in the statute, under the influence of drugs, alcohol, or the combination of them. So you don't have to have too much of one or too much of the other. If you have a combination to the extent it causes you to be under the influence, affect your ability.
And we just got a call in with a question which might overlap what we're talking about here, and our caller asks, do the DUI laws apply if I'm using other drugs, like he says major crack, and that tied in, and of course they do, but what is, you know, before we talked about the odor of alcohol, that's pretty easy for the officer to apply. But say a light's out or somebody goes a little past the red light or the yellow light or something and stops, what are they looking for? The established things to look for drugs.
Well, marijuana is somewhat easy because of the odor, and so officers are trained to smell that odor. And even if they have a slight odor or have a suspicion, they can call a canine unit and do what's known as a free air sniff, and they can walk that dog around the car. That can alert perhaps to other drugs. The other things, I spoke to a trooper this morning when I was in Vandalia Municipal Court, and he had just returned from a training course on how to identify or notice different ways people behave when they're on drugs. So it's not just bloodshot eyes, it's these jerky behaviors that people may exhibit, or it's looking for marks on people's arms that may be fresh marks. And those all lead to impaired driving, because that's what we're talking about. When people are on drugs and they're impaired, they could cause an accident. That's what we're concerned about.
What are the things that you mentioned while we were doing the field sobriety coordination tests, Larry, is that people don't have to say anything if they're stopped. And usually I think the standard thing is the person will tell the police officer, I had 2 beers. We don't have any 1 beer, 3 beers, or just a couple or something like that. But you don't even have to say that, do you?
You're not obligated to really make any statement that will convict you of anything. You have to cooperate with the officer to the extent, if he asks you for your license and registration, you have to provide that. If he asks you your name, now, when he starts wandering into an area of, well, where have you been, where are you going, you know, how many drinks have you had? You know, these are incriminating questions which your answer could hurt you. And you can always refuse to answer that. You can always ask him a question. Well, why do you want me to tell you that? Or, you know, I'm not trying to give advice to people about what to do, but once it goes beyond the scope of the stop and the purpose for speeding or traffic light, you have a right to then say, you know, I might want to have my lawyer here before we answer any more questions, or you might decide not to say anything.
So questions as to ownership of the vehicle or your privilege to drive are completely acceptable questions.
Yes.
But
and you should cooperate and are required by law to make certain identifying information available.
But questions about the nature of what and circumstances of what could potentially be charged, you do have the right to say nothing.
Sure.
Okay.
And people always forget, you can ask for your lawyer. We have that right.
Even if you don't have one at the time.
Even if you don't have one, if you can't even afford one, they have to tell you about your right to have one provided for you at their expense.
Okay. We have about 10 or 15 minutes left. I'm seeing 12, but our floor director said 15. Maybe we'll go 3 extra minutes. I don't know. I do want to take this break, give our guests a chance to catch their breath, but I wanted to let you know you are watching You and the Law here on DATV Channel 5. We stream live at datv.org. We're talking about drunk driving tonight with some exceptional guests. Mr. Larry Denny, defense attorney in our county and many others nearby, and Mr. Chris Eppley, who prosecutes criminal cases and DUI cases in the city of Vandalia, which is just north of us here. And we're sponsored by the Dayton Bar Association. Won't give you the whole spiel about them tonight, but you know, we have a lawyer referral service. Call the bar. If you don't have an attorney, they'll find you one, or find one that you might find acceptable. And we have a program called Wills for Heroes for first responders. So if you are one of those police, fire, first responders, EMTs, you don't have a will, give them a call. So I did want to talk in the last few minutes about the breath tests, of which you said the new ones come in, and I'm not sure whether we have it up in use at Vandalia or not, or whether there's any challenges to it. What's it supposed to do, and what are the challenges to its effectiveness?
Well, the new machines called the Intoxilizer 8000. The reason they call it 8,000 is it costs $8,000.
Why
and,
not?
They're about to make the 9,000 because of all the trouble with the 8,000, and it's going to cost 9,000. But at any rate, the good things about that machine are that it takes 2 tests. The old machine, the Data Master and the Intoxilizer 5000, only provided 1 breath test. So out of the middle of the night, we have 1 breath test, and we can't see if it's reliable or accurate by measuring it against another one right next to it. The new 8000 does give dual testing real quick in time. Within 2 or 3 minutes, they give you a second test, and if those 2 tests are close together within a certain range, you know that that test is fairly reliable. At least that's a scientific theory. So there are many things about the new machine, but there's a lot of problems with it, and they're being challenged throughout the state in different jurisdictions, and they're not doing very well in terms of proving its reliability. Some jurisdictions in our area use them, some of them don't. In fact, there are more that don't and that use the old Data Master and the old 5000 than use the new one.
Okay. Chris, so what's it supposed to do? I mean, how does that help you with these tests?
Well, these tests and the ones Larry is talking about help us to give us the figure, the number. Are we within the low tier or the high tier? And that's a big thing. That's a big deal because ultimately
it quantifies
it quantifies it, exactly. If you're refusing a test and yet you're impaired, we can still prosecute that. But if we have a number that we can assign to what happened to you that night, that gives the prosecution, the defense counsel, as well as certainly the judge, because the judge is the one who imposes the sentence. And the judge has to follow the law. So if it's a high-tier test, he or she's going to have to impose that high-tier sentence to the operator of the vehicle.
And there's 2 sections of the law. One is without the test and one is with the test, I guess. So if you don't take the test, that doesn't mean you're escaping necessarily.
That's correct. You could still fail all of the tests that Larry had just performed for us earlier this evening. Combine that with your impaired driving, and we can still prove an OVI prove a case for OVI.
Okay. Let me, we have a few minutes left here, and we do have a question, which I think is very interesting, and it's about liability. And this person calls in and says, as a bartender or owner, do you have a responsibility over whether patrons drive drunk, and are you liable?
Well, that's more of a civil question, but
right.
Yes, the law does impose on bartenders an obligation not to assist somebody in becoming over the limit impaired, knowing that they're going to drive from your facility. I think everyone has common sense and knows that they shouldn't do that. Should tell them to call a friend or call a cab. And many bars do that. But it's often difficult for the bartender to know at that minute whether that person's impaired because they've been sitting still right in front of them. Not until they've actually walked outside, done a little movement, and time has passed, and they get in their car and they're driving down the road, that all that alcohol comes full circle and has effect on them. So even though they know they shouldn't give them too much to drink, sometimes the visual impairment isn't apparent to them right away.
So most of the places where I think the officers are looking for this type of activity are places where a lot of people go. Bands are at them, and we had a show last month about the liquor laws and things like that. But it's hard to look at them, and if you're the owner and what you've talked about today, people are trained to do these tests and what to look for. So I know that doesn't probably come within the purview of prosecuting these cases, but what do you think? Something can be done about it more, or more liability?
Liability is a term of civil law,
right.
And so we prosecute criminal cases, and I don't recall it since 2000 prosecuting a bartender for serving someone who was subsequently arrested for OVI or having a car accident. Again, that could be a civil matter, and the bar is sued and their insurance policy comes into play, but that's not something that we would do in Vandalia Municipal Court from the prosecutor's standpoint.
We have about 5 minutes left, and I did want to bring up one point, and I think in the 60s, 70s, and 80s, there was a proliferation of drinking, driving, lots of accidents, and lots of deaths involved. And I read a statistics for the Mothers Against Drunk Driving, and I think there's Students Against Drunk Driving, and there might be others, that since 1980, I think the accidents from drunk driving have halved. Is that accurate?
Yeah, the statistics are down, and what's even more interesting, I think, is that there are more people that are injured or killed by way of someone texting and using their cell phone than they are drunk drivers now. So even though we don't want anyone to hurt anyone or kill anyone by being drunk and driving a motor vehicle, I think we need to be alert to a new hazard that's out there, maybe even more, and I think you'll see laws come more into effect about texting.
Well, at least when you're drunk driving, you're trying to drive.
That's right.
Whereas when you're texting, and I saw a commercial on TV, and of course I'm not vouching for every commercial I see, but they indicated it takes about 5 seconds to look at your phone to text something that could be understood on the other side, and that seems enough time to run into something, or?
That seems right to me. It draws your attention away from what's ahead of you and the cars ahead of you and what's around you. And I think that's a new part of the law that's going to be into effect here in the next couple of years.
And of course, we talk about defense of drunk driving, which you've been very effective at, but and you've told us this before, that you would like to see also, as well as the prosecutor, people rehabilitated. If you get one, maybe not more than one, and what emphasis do we put on that?
Yeah, I think that we have to look at whether this is a person that's just thumbing their nose at the law and really don't have a disease of impairment, versus someone who may have an illness, an alcoholism. And if they are ill, we need to treat this as a disease. Now, to protect the public, we need to keep them out of a car in the meantime. But to punish them with long jail terms is not the way to treat a disease. We need to keep them out of the car, but I don't advocate punishing someone for being sick. So I think we've taken a little bit of a throw the baby out with the bathwater approach to the repeat offender if it's an illness. but we do want to keep them out of the car.
And I think that has changed over the years, that and I think if not all of the courts in our county have rehabilitation or some diversion programs.
Only for first offenders are
Right.
there any diversion programs, and very few of those. But the second offense or the third offense has mandatory jail time, 30 days, 60 days, no matter whether you have an illness or not. And you know, sometimes that may be not of assistance. That may just make the person thirstier.
Mm-hmm. And I agree with that regarding the first offense person who has who's made a mistake. But as we look into the law, you have your third offense or fourth offense or more within 6 years, you have to forfeit your vehicle.
Well, they're not getting the idea.
Right. If it's titled to you, we're taking your vehicle away from you. And so we're no longer really rehabilitating you. We're punishing you. We're trying to correct this behavior because you haven't gotten the right idea that it's not the thing to do. You could hurt yourself or hurt someone else.
Okay, our floor director tells us we're getting close. I'm looking at the monitor and it says I've got about a minute. He might think I have less. I don't know. He's telling me to get going here. So anyway, you've been watching You and the Law. We've been talking about drunk driving. We've had Larry Denny, a great defense attorney here in our county and in the area, and Mr. Chris Eppley, a fine prosecutor and fine lawyer. He's with the City of Vandalia prosecuting. I'd like to thank all the volunteers behind the scenes who have made this program possible. We are at the holiday season. You are allowed to drink and drive, but don't drink too much. It's better to maybe have somebody else drive you home if you want to have a really good time. So enjoy the holidays. We'll see you next year. I've been your producer and host. I'm Mike Monta. Thank you for joining us. We'll see you next time. Good night.